Sige, let us continue with our discussion this time. I think we have already ended with Rule 113. We have discussed and the arrest. Okay, and we have learned that the definition, the technical definition of an arrest, and the forms of arrest, like the actual restraint and the voluntary submission. And then we also learned that an arrest could be with a warrant, which is a general rule needed. And we also have the warrantless arrest, where we learned that there are three instances recognized by the rules where a warrantless arrest or an arrest without warrant is considered still as a um, valid action of the state. So again, the constitutional foundation here is Article 3, Section 1 and Article 3, Section 2. Okay? So, no person shall be deprived. We're done with arrest. That is with respect to your liberty. Now we go to your property. So Article 3, Section 1 says that no person shall be deprived also of property. But if you read closely Article 3, Section 1, ang sabi dyan is the prohibition is only when there is no due process of law. Because Article 3, Section 1 says that without due process of law. If there is a due process of law, then the state can deprive a person of his property. Last time, sa arrest, the subject matter there is the liberty of the person. But this time, we are talking about the property of the person, particularly personal property, okay, or movable property. Now, in relation to that, we have Article 3, Section 2 of the 1987 Constitution. We are still in the constitutional foundation, ha? The rights of the person to be secure in their houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. Okay? No search warrant shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Ito yung ni-raise ni Mr. Malnegro last time na there is still a need for the judge to issue to determine probable cause. Yes, but not pursuant to preliminary investigation. The probable cause here is for the issuance of a warrant of arrest in Rule 113 and search warrant in Rule 126. Ano bang kaibahan ng warrant of arrest sa search warrant? Warrant of arrest is proper when the goal is to take the person of the accused. Okay? So, to take the person of the respondent, tama ba? Is it accurate? Hindi. Because a warrant of arrest, the presumption or the presupposition here is that preliminary investigation is already done and there was probable cause found by the investigating prosecutor. That is why it was transmitted to the court, and the court now in effect or consequently issues the warrant of arrest. The goal there is to arrest a person. Arrest in Rule 113, as we learned, is the actual restraint or the voluntary submission of his person. Okay? So that is a different document or issuance of the court from that of a search warrant. Both of them are warrants, but the object of the search warrant is not the person, but a property, particularly a personal property or the movable property. Okay? Is it possible for the court to issue a search warrant even without preliminary investigation? The answer is yes. That is why if you take notice, yung search warrant natin na rule nasa last, nasa Rule 126. But I need to put it immediately after Rule 113 for you to appreciate better the difference between the two. Okay? So, sa search warrant, hindi kailangan na kailangan na nag-undergo ng preliminary investigation. In fact, kahit wala pang kaso, pwede kang mag-apply ng search warrant. Even if wala pang information, wala pang resolution wala, meaning kasi wala pa talagang nangyari, pwede ka talagang mag-apply lang ng search warrant. So pag-uusapan natin ngayon yung search warrant. Okay? So we have already discussed the difference. Okay? What is a search warrant? Punta tayo sa Rule 126, Section 1. It is an order. Okay? Order in writing. Hindi pwedeng oral. Issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. So, we learned last time in Rule 113 that as a general rule, only the court can issue a warrant of arrest. How about the search warrant? General rule, yes, it's also the court which has the power to do so. Okay? But as we also realize, sa warrant of arrest, merong exception dyan. The President can issue kapag meron ng final order of deportation. Sa search warrant naman, aside from the court, the Customs Commissioner and his authorized representatives can also issue a search warrant under the Tariff and Customs Code. Okay? So, yan. Let us now go to Rule 126, Section 2. So, paano ba nag-i-issue ang court ng search warrant? Kailangan ba na merong resolution ang investigating prosecutor and then nag-issue ng information and then transmit it to the court before the court can issue a search warrant? The answer is no, because again, as I was telling you, hindi kailangan na merong kaso before ka makapag-apply ng search warrant. Even if wala pang kaso, pwede ka nang mag-apply. An application for search warrant under Rule 126 Section 2 is that it shall be filed with the following: any court within whose territorial jurisdiction a crime was committed. Not necessarily there is a case, but there is a crime, could be, but not necessarily na nakapag-file na ng kaso. Okay? For compelling reasons stated in the application, any court within the judicial region, not territorial jurisdiction, where the crime was committed, if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. So, the second is usually observed kapag wala pang pending case. Okay? Is it also possible to issue a search warrant if meron ng pending case? The answer is with all the more reason, pwede. Okay? Ang point lang dito is that, unlike sa warrant of arrest, ang search warrant pwedeng ma-issue kahit wala pang pending case. Okay? However, if the criminal action has already been filed, the application shall only be made in the court where the criminal action is pending. Ito yung sinasabi ko sa inyo. Meron mang kaso or wala, meron na bang pending case or wala pa, pwede ka talagang mag-apply ng search warrant. The difference is that kapag wala pang pending case, then you have to file your application. Okay, what do you need to file? You file an application for search warrant before the court within whose territorial jurisdiction a crime was committed, or any court within the judicial region where the crime was committed if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. Okay? However, if meron ng pending case, then doon ka sa court kung saan ang case pending. Okay? So, yan. There was a question before kung kailangan ba ng certification of non-forum shopping sa application ng search warrant. The answer is the case of Kenneth Roy versus Taipin, May 11, year 2000. The Supreme Court said hindi kailangan because a search warrant is in the first place not a pleading. Okay? In the same case also, the authority to issue a search warrant is inherent in all the courts and may be effected outside their territorial jurisdiction. So meaning to say, pwedeng mag-conduct ng search warrant or ng search pursuant to the search warrant issued by the court even if outside sa territorial jurisdiction ng korte na nag-issue ng search warrant. Okay? So, sir, ano bang kaibahan nito sa sinasabi ng Rule 11126 Section 2? Ang sabi lang doon kung saan ka maka-apply. Okay? But as to the coverage of implementation, the coverage of the implementation of the search warrant, kahit saan, okay, kahit saan sa Pilipinas, even outside the territorial jurisdiction of the court issuing that search warrant, pwedeng i-implement yan siya. Okay, that is in the case of Rui versus Taipan. Okay, so what are the guidelines here? The case of Malaluan versus Court of Appeals lay down the guidelines whereby the court where the criminal case is pending, if the case is pending, shall have the primary jurisdiction to issue the search warrant. An application of warrant in any other court is possible if there are extreme and compelling circumstances and applicant satisfies the latter court of such reasons, which may or may not give due course depending to the validity of such jurisdiction of the court. When you apply for a warrant, just because it is stated under the rules that you can apply for a warrant outside of the place where the crime was committed, you should not expect that a warrant will be issued, okay? Because it is still within the court's decision if the reasons are compelling enough. So meaning to say, it is under the court's jurisdiction. Once the court issues a search warrant, then ito na yung sinasabi natin, ito na yung sinasabi ni Rui versus Taipan na it can be enforced all over the country. We also have the case of Spouses Marimla versus People, GR number 158467, October 16, 2009, penned by Leonardo de Castro. Okay? The following are authorized to act on all applications for search warrants involving heinous crimes, illegal gamblings, dangerous drugs, and illegal possession of firearms. The executive judge or the vice executive judges of the RTC, okay? So they can, okay? Applications shall be personally endorsed to the court that will grant the search warrant. Okay? So, yan. Remember, wala pang case dito. Okay? Now, ano muna ha? Let us now go to Rule 126, Section 3. Okay, Rule 126, Section 3 provides that a search warrant may be issued for the search and seizure of personal property. You cannot seize a real property because it's immovable. So, the only object here of search warrant is personal property, the movable property. Okay? Now, have you taken up your property law? Do you remember yung what is a real property and what is a personal property? Okay? Do you remember that discussion there na what if printing equipment siya? Okay? Is it considered as personal property or real property? Okay? If the printing equipment is attached to the building, it becomes real property. And because it becomes real property, then it cannot be a subject of search warrant, even if it is movable, because again, it has already been attached to the ground. Okay? So remember that. Yan yung implication dyan. Pero anong lahat pa ng personal property pwedeng maging object ng search warrant? Yan yung dapat nating klaruhin sa Rule 126 Section 3. Sabi dyan, the personal property must be a subject of the offense. Okay? It must be the item stolen or embezzled and other proceeds or fruits of the offense, or it was used or intended to be used as the means of committing an offense. Okay? So, yan. How do you compare search warrant from a writ of rep levin? Search warrant is an order. A writ of rep levin is also an order. Both of them, ang object ay personal property. Okay? But a search warrant is more specific to objects or to personal properties, the subject of the offense, stolen or embezzled, and other proceeds or fruits of the offense, or used or intended to be used as the means of committing an offense. If it is a personal property and hindi nahulog sa mga category na yan, it could be that the search warrant is not the proper application that you should ask from the court. But you better go for the issuance of a writ of rep levin. Okay? So whenever the search warrant is void, must the authorities return the illegal items to their owners? Like for example, the search warrant is defective, but the authorities still implemented the search by using the defective search warrant. And nakita talaga yung mga illegal items. Ngayon, dahil defective nga yung search warrant, kailangan ba nating isauli yung mga illegal items na recover? The answer is no. Even if the drugs seized or even if the illegal items were seized, okay, and if they contain the proper chemical, if the seller has, if the search warrant, the items be returned to the owner. Okay? So, yan. So, kahit void yan sa ulit na yung items, because the first items are items or stolen, right? Okay? Let's go to Rule 264. Okay? A search warrant shall not issue except upon probable cause. Okay? So, Mr. Negro, ito yung probable cause na sinasabi natin. And this is a different probable cause from the probable cause that we learned in preliminary investigation. So, ano ba yung probable cause na ibig sabihin dito? This is explained in the case of People versus Aruta. Such facts and circumstances which could lead a reasonably discreet and prudent man to believe that an offense has been committed and that the items or the articles or the objects sought in connection with the said offense or object to seizure and destruction by law in the place to be searched. So, di ba? Iba na yung definition niya sa probable natin sa preliminary at saka probable cause doon sa warrant of arrest. Okay? So, mag-i-issue lang cause. And the probable cause here is defined in People versus Aruta. In connection with one specific offense. Okay? So, one specific offense. In the case of People versus Dichoso, okay? And the case of Coca-Cola Butlers versus Gomez. Unahin na itong Coca-Cola Butlers versus Gomez. When an offense is punished by different provisions of the same law, like different sections pero under the same law, there is no need to write the specific provisions, and issuance of single warrant is fine. When the accused is charged with several counts of the same offense, the issuance of a single warrant is also sufficient. If it is violation of BP 22, every check must have its own information, di ba? One information, one crime ba yan, di ba? Mo na to ang rule. But if it is warrant or search warrant for BP 22 and you want to have the different stubs of the check, for example, 100 checks ang involved, Okay? The judge can issue only one warrant for the 100 checks. Okay? It is not enough to just base the issuance of search warrant upon the testimonies of the witnesses and the complainant. The judge must personally determine if there is really a crime involved. There is, in the case of Coca-Cola Butters versus Gomez, GR number 154491, November 14, 2008, penned by Justice Brion, the Supreme Court said here that there is no crime in hoarding bottles. The acts of Pepsi did not constitute a crime under the provision of the Intellectual Property Code. Nangyari kasi dito, the competing company hoard the bottles of Coca-Cola. So, tingala Coca-Cola na sige mig produce og botelya, mahutdan man gyapon ta. What happened? It's because of the competing company hoarding their bottles. And the Supreme Court said here na there is no crime. Okay? So because there is no crime, can you apply for a search warrant? Okay? So, yan. Because, again, it's not an object of the crime. It has not been used for a crime because in the first place, there is no crime. Diba? So, yan. In the case of People versus Dichoso, 223 SCRA 174, the Dangerous Drugs Act is a special law that deals specifically with dangerous drugs which are subsumed into prohibited and regulated drugs and defines and penalizes categories of offenses which are closely related or which belong to the same class or species. Accordingly, one search warrant may therefore be validly issued for the said violations of the Dangerous Drug Act. So, in connection with one specific offense, there is only one search warrant there. Again, those cases will tell us to not literally, okay? And this is to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce. And the judge must, before issuing search warrant, personally examine in the form of searching or probing questions and answers in writing and under oath the complainant and the witnesses he may produce on the facts personally known to them and attach to the record their sworn statements together with the affidavit submitted. This really applies in search warrant. Okay? Kasi mag-hearing man yan siya. I-hearing man yung application mo. Okay? And that is also required under Rule 126 Section 5. Okay. So, unlike sa warrant of arrest that the judge can merely look at the affidavit complaint, and the affidavit, the resolution, and the information of the issuing or the investigating prosecutor and determine whether to issue a warrant of arrest. Dito talaga mas kailangan ng extra effort sa part ng judge na mag-determine ng probable cause. Okay? So, iba ang probable cause na ino-observe ng judge kapag issuance of warrant of arrest. Iba rin yung probable cause na ini-exert ng judge kapag ang concern is issuance of search warrant. Okay? So, there must be a personal examination talaga on the part of the judge because remember that a search warrant may be applied even if walang probable cause sa preliminary investigation kasi nga pwedeng mag-apply ng search warrant kahit wala pang pending case. Okay? So, yan. I have here two cases that I want you to compare. Let's have the first case, People versus T. Okay? Here, there is an omission to the transcript of deposition of the witnesses. Okay? Hindi na nabasa ng judge and then the judge still issued a search warrant. The Supreme Court said it's not fatal. Okay? In the case of People versus Mamaril, the clerk of court of the said court could not produce the sworn statements showing that the judge examined them in the form of searching questions and answers before the issuance of the search warrant. And the Supreme Court said that because the clerk of court could not produce that, the search warrant is tainted with illegality. Please take note of these two cases. Okay? So, yan. In short, kailangan talaga na mag-produce ang clerk of court ng sworn statement na the judge, the issuing judge, personally examined in the form of searching questions. That is why meron pang hearing. Meron pang hearing sa application because that is where the judge will exercise the requirement na kailangan there is a personal examination on the part of the court in a form of searching questions. Okay, if you cannot do that, then the judge still issued a search warrant, then that is tainted with illegality. Another requirement here under Section 4 is that the search warrant should particularly describe the place to be searched. Okay? So if the place to be searched is Unit 2 of XYZ, for example, you cannot search Unit 1 because klaro man na Unit 2 ang sinasabi ng search warrant. You cannot also search Unit 3 unless if there is a connecting door. Okay? So, yan yung sabi ng court. So, again, the search warrant must indicate or particularly describe the place to be searched and the things to be seized, which may be anywhere in the Philippines. What is the difference between a general warrant and a scattershot warrant? Okay, remember nung yung sa warrant of arrest na discussion natin, we said that general warrant is void. Like for example, kapag John Doe, and then wala ring particular description as to the person to be arrested. That is a general warrant and that is fatal. That is void. Okay? Here, I am introducing you two kinds. General warrant and a scattershot warrant. A general warrant is a warrant which fails to describe the place to be searched, the object to be seized, and the specific offense which the warrant is issued related to. So, that is a general warrant. And this is a void and unconstitutional warrant, search warrant. What about scattershot warrant? A scattershot warrant, on the other hand, is a search warrant which is issued for more than one offense in violation of the rule that a search warrant must only be in connection with one specific offense. Okay? So, it's not waivable. It is really void. Yan yung sabi ng court. Okay? So, yan. Question from the class? If you have questions, by the way, you because it is an asynchronous session, you put it on the comment box so that we can address. Okay? So, yan. Now, what if the search warrant states that you seize a caliber 45 gun and a car? The gun should be seized. But ang sinabi you seize a caliber 45 gun and a car. Yang car na sinasabi dyan is very broad. While the gun can be identifiable and can be seized, okay, determinable, but the car, we cannot do that, okay, because it's not specifically identified. So what will happen? Is the search warrant void? The answer is no, not entirely. That is what you call warrant is separable principle. So kung ano lang yung specifically identified, okay, yun lang yung i-seize mo. Yung broad, wag mo yung i-seize. Okay? And we cannot just say na because broad yung isang item dito, the entire search warrant is void. Because we have this warrant is separable principle. Kung ano yung pwedeng ma-separate na void, kung meron pang mga valid dyan na mga items na pwede nating i-seize, then the search warrant can still be used. Okay? So, yeah. Now, let's proceed to Rule 126, Section 6. Okay? Rule 126, Section 6. If the judge is satisfied of the existence of facts upon which the application is based, or that there is probable cause to believe that they really exist, then the judge has nothing else to do but to issue the warrant, which must be substantially in the form prescribed by these rules. Can the break-in and break-out principle apply also in the execution of the search warrant? Let us see in Rule 126, Section 7. The officer, if refused admittance to the place of directed search after giving notice of his purpose and authority at hindi pa rin siya binuksan, may break open any outer or inner door or window of a house or any part of a house or anything therein to execute the search warrant or to liberate himself kapag nilakan siya, di ba? Any person lawfully aiding him when unlawful detained therein. So, meron pa rin. Rule 126, Section 8, no search of a house, room, or any other premise shall be made except in the presence of the lawful occupant thereof or any member of his family. Pag wala ang lawful occupant or wala rin any member of the family, then in the absence of, or well, in the absence of two, or in the absence of the latter, then two witnesses of sufficient age and discretion residing in the same locality may be used. In short, the lesson here is that when you conduct a search, there must be witnesses. A witness who is a lawful occupant or a member of the family. If wala sila, then kumuha ka ng dalawang witnesses. Okay? So, Rule 126, Section 8 is the rule. Now, Rule 126, Section 9. The warrant or the search warrant must direct that it be served in the daytime. Hindi pwedeng gabi, hindi pwedeng anytime lang. Unlike sa warrant of arrest, no? Or sa arrest, na pwede siya at any day, anytime, day or night. Dito, daytime. Unless na lang if the affidavit asserts that the property is on the person or that the property is in the place ordered to be searched, in which case the direction may be inserted that it may be served at any time of the day or night. Wala ganun sa order. General rule out that it can only be served in the daytime. Okay? Section 10, search warrant shall be valid for 10 days from its date. Thereafter, it shall be void. Ito sa mga differences ng warrant of arrest at search warrant. Kasi dito, meron talaga ng expiration period. 10 days from issuance. After that, it expires. Okay? May a search warrant be served twice during its lifetime or kung ano lang dyan siya, kaisa lang dyan siya pwede magamit. In the case of Mustang Lumber versus Court of Appeals, the Supreme Court said that yes, as long as hindi pa yan siya expired, you can execute or use that multiple times. Okay? Now, the officer seizing property under the warrant must give a detailed receipt for the same to the lawful occupant of the premises in whose presence the search and seizure were made, or must in the presence of at least two witnesses of sufficient age and discretion residing in the same locality, and then leave a receipt in the place in which he found the seized property. Okay? The receipt is only given if there are seized items. If there is nothing there that was seized, then wala kang dapat i-issue na resibo. Okay? Now, let's go to Rule 126, Section 12. Rule 126, Section 12 provides that the officer must forthwith deliver once there is already a seizure of the item. The officer must forthwith deliver the property seized to the judge who issued the search warrant, together with a true inventory thereof, duly verified under oath. Okay? So remember, 10 days after the issuance of the search warrant, the issuing judge shall ascertain if the return has been made. If yes, then the judge shall ascertain whether Section 11 of the rule has been complied with, and shall require that the property seized be delivered to him. The judge shall see to it that subsection A hereof has been complied with. Excuse me. If walang return na ginawa, the judge shall summon the person to whom the warrant was issued and require him to explain bakit walang return. Okay? Remember that there is an expiration date with respect to search warrant. The return on the search warrant shall be filed and kept by the custodian of the logbook on search warrants, who shall enter therein the date of the return, the result, and other actions of the judge. Now, remember that the violation of this rule is considered as a contempt. Okay? It shall constitute a contempt of court. Okay? Questions from the class? Question? Okay. Now, we just discussed search warrant. Okay? But do you know that, like arrest, a search could also be done legally and without violation of the rules, without violation of the Constitution? Okay? It can also be done without the warrant or without the search warrant. There are recognized exceptions there. Or there are recognized instances where a warrantless search is valid. And we will discuss that on the next video lecture. Did you learn something today? This is still part of the exam. Okay? So good luck, and we will have the next discussion on the next video lecture. God bless everyone and have a good day.